Is an MLA or an MP a public servant in a case of rape of a minor? This is the moot question before the Supreme Court as it hears an appeal from the Delhi High Court order holding that an MLA is not a public servant under the POCSO Act. The arguments reached the Supreme Court after the Central Bureau of Investigation challenged the Delhi High Court order granting relief to Kuldeep Singh Sengar, a former BJP MLA from Uttar Pradesh's Unnao district. Sengar, a four-time MLA from Unnao and MLA from Bangarmau constituency at the time of the offence, was arrested and charged by the CBI for the rape of a minor girl from his constituency. He was convicted of the rape in December 2019, as well as in a different case of hatching a conspiracy to kill the father of the victim while he was in judicial custody. Hearing the appeal filed by the Central Bureau of Investigation, the bench, led by Chief Justice Suryakant, observed that the court ordinarily does not stay orders of lower courts when an under trial or convict is released. However, since Sengar remains in custody in connection with another case, the Supreme Court found it fit to stay the Delhi High Court order that granted him relief. Sengar is serving a jail term in the murder case of the victim's father. The High Court had suspended the sentence of Sengar from jail for the remainder of his life, primarily on the ground that he did not qualify as a public servant under the provisions of the POCSO Act. This was because that the act that deals with the offences of rape of minors in the country does not have a public servant defined explicitly in it. Accordingly, the High Court adopted the definition from the Indian Penal Code, which also does not expressly define an MP or an MLA as a public servant. Hence, the High Court prima facie held that Sengar should be punished only under the provisions of the penetrative sexual assault and not the aggravated form of it, because he was not a public servant. Representing the CBI during the hearing on appeal, Solicitor General of India Tushar Mehta argued that there is only one aspect that differentiates between the two types of sexual assaults under the POCSO Act. He argued that it was just the position of the offender that could determine whether it was an aggravated penetrative sexual assault or a penetrative sexual assault. He said that among all categories outlined in the law that fall within the aggravated category, there is a common element that the offender was in a dominant position with respect to the victims. Mehta argued that Sengar was a powerful MLA of his constituency. Notably, the victim was a resident of his assembly constituency and was raped months after he was elected as an MLA in March 2017. Mehta also pointed out what he referred to as an error in observation of the Delhi High Court and said that those observations would create a situation where a police constable in the security of an MLA or MP would be covered under the rigorous provisions for aggravated penetrative sexual assault. However, the MP MLA would be outside of its ambit. Based on these parameters, Mehta requested that the Apex Court bench led by Chief Justice Suryakant adopt a contextual definition of a public servant rather than a literal one as defined in the Indian Penal Code. After settling the argument on Sengar's qualification as a public servant, the High Court prima facie held that he should be sentenced for penetrative sexual assault that attracts a minimum punishment of 10 years. The matter was not straightforward even on this aspect. The minimum sentence for the offence of rape against a minor was enhanced in 2019 when the government amended the POCSO Act. The High Court observed that since the offence occurred before the amendments, Sengar would be punished only under the law in force at the time of the offence. Hence, as Sengar had already served more than 7 years, which was the jail term under the old provisions of the POCSO Act, he was entitled to relief under Article 20 of the Constitution of India, which guarantees fundamental rights to citizens. Mehta, however, argued vehemently against it. He said that the amendment was a mere enhancement of the punishment considering the nature of the offence. He said that the sexual assault against a minor was not created as a new offence in 2019 and that it was an offence even on the day it was committed by Sengar. He cited several judgments of the Apex Court to drive home the point that the government is barred only from defining an offence retrospectively. On the contrary, Mehta argued that the government has the power to enhance punishment for any offence through legislative amendments, which was done in the case of POCSO Act. The CJI orally agreed with the Solicitor General's examples and indicated errors in the Delhi High Court order. The bench asked the counsels of Sengar to file a counter affidavit within 4 weeks. Well, that's all we have in this episode of The Print. My name is Mayank. Keep watching The Print and subscribe to our YouTube channel.